Let me bring in my guest, still with us to discuss, criminal defense attorney, former prosecutor David Bruno. David, I want to get your reaction. First and foremost, let's start with the original verdict by this jury, finding him not guilty of the more serious charges of that racketeering, sex trafficking, but did find him guilty of transporting for the purpose of prostitution. Could have faced up to 10 years, according to sentencing guidelines. I think it's anywhere between 2 and 5 years. Your quick reaction to that?
Yeah, a good day for Diddy, no doubt about it. You know, yeah, he lost that detention motion, but, you know, these charges that he's found guilty of have no mandatory minimums whatsoever. What that means is there's maximums of 10. He could theoretically be sentenced to time served. The guidelines are relatively low. You're talking about anywhere from a little over 2 to upwards of 5.5. The prosecutor in their detention motion today saying that he's exposed to 51 to 63 months, and that's because of the enhancements on the federal sentencing guidelines off this base offense, which is 15 to 21. So on the charge, he generally is in 15 to 21, but they're arguing multiple victims. They're also arguing obstruction of justice, and they're arguing the grouping and duress as well. So there are a number of things that the prosecutor's trying to do to jack it up on the guidelines. But with that being said, it's still going to be within the judge's discretion, somewhere in the minimum, in that range, so to speak. And the sentencing guidelines are discretionary. Usually that's where the judges go. But at the time he steps in front of that court for sentencing, he's going to have a considerable amount of time served, Michael, where I would imagine that the defense attorneys are going to be arguing for time served, hoping, and then even if, he's likely going to be in a camp for the rest of his time. So a good day for Diddy, considering that he could have been exposed to a lifetime in prison on the top counts, and he was acquitted on those counts, and he's only left with these 2 counts that do not have mandatory minimums.
Yeah, fair enough. And folks, we just heard from Mark Garagos. He's the father of one of the defense attorneys, Tenny Garagos, also good friends with Sean Diddy Combs, has represented him in the past. We're waiting, I believe, he said in a few minutes his daughter will come out, speak for herself, so we're waiting for that to happen. So let's go now, David, to the denial of bond in this case. One of the things that the judge said was that he still, I guess, considers Sean Diddy Combs a threat to the community because, again, he's someone who has participated in and clearly was involved in and admitted to domestic violence.
Yes, let me explain this, okay? Because I do have the filing of the government. And what they were arguing, and the judge did follow this, is that the Bail Reform Act it demands mandatory detention because of the violent crime. And the Mann Act, which is in Chapter 117, is in that chapter that's defined as violence. So basically, following that law, it shall be detained unless there's 2 things that happen: that there's a substantial likelihood of an acquittal or a new trial on appeal. The government recommends no jail. That did not happen. And clear and convincing evidence that the person is not likely to flee or pose a danger to another person or the community. So what happened was, because of the violence that is defined in the code and that the Mann Act falls under the crimes of violence, it was a shall detain that shifted the burden to the defense, and they would have had to prove those 2 prongs, which they could not. That's why the question of violence was so important for that detention hearing. And you heard from the court saying to the defense counsel, well, in your closing argument, you conceded violence. You conceded that there was domestic violence, but it didn't rise to a level of sex trafficking or racketeering. And with that being said, now the question becomes, was that violence for the purposes of detention? Who had the burden? And once it was defined as violence, the government argued it, that then it shifted to the defense because of the act of violence.
Joining us to discuss is criminal defense attorney and former prosecutor David Bruno. David, first and foremost, you heard the press conference there by the defense team, and they hailed it a great victory. I ask you, was this in fact a great victory?
Yes, for the defense team. I mean, without a doubt, they're in federal court, top counts, the racketeering and the sex trafficking. And certainly if he was found guilty of those counts, he would have been in jail for the rest of his life. You know, but Michael, we've all been talking about trying to smash these facts into these federal crimes. Because the racketeering, you know, it required the organization. It was the enterprise that had to be proven, that affected interstate commerce, pattern of racketeering. There were a number of elements that really weren't fitting straight within that bad boy records in this organization. Also, on the sex trafficking allegations, you had former girlfriends. But what also was required there was that there's the purpose to engage in a commercial sex act, meaning of value. And then there also had to be the element of force, fraud, or coercion. So those were essentially the counts that he was found not guilty of. And that really was a stretch to get those fact patterns in. So it's not guilty on the top. There's those two interstate travel for the transportation of prostitution. But I think there's a worthy conversation, too, about domestic violence. Because say what you will about this particular verdict, there was a video that we all saw. That was the nucleus of the government's case. And that certainly could have been a state case right then and there if it was brought timely. There was also allegations of trying to get that video and paying off people to get the videos and things like that. But this is a good day for Puffy, P. Diddy and his team, his legal team up there. But it's not a great day for some of the people that experienced what they testified to. So I think it's a worthy note to bring forth on this day that we're talking about this verdict.
Yeah, and you're absolutely right. And one of the things that it sounds like could happen in this case is that this whole domestic violence aspect of the case, which again, Mark Agnifilo and this defense team admitted from the very beginning. They say, hey, look, we fess up to that, but we're not charged with that particular crime. Again, statute of limitations had passed, and that's one of the reasons we see him in federal court on these RICO-type charges. But that could come into play in sentencing. Talk about that a little bit.
Yeah, sure. So the sentencing guidelines are applicable. Now, the statutory maximum is 10 on the transportation, and there's no mandatory minimum. So it could be anywhere from no jail time all the way up to 10. So where the next level comes in is that the probation department of the court is going to do a pre-sentence report. And they're going to put together these other facts that could be enhancements to bump up the base levels. Because this particular crime that he's been convicted of is what we call a base level 14, which generally would be 15 months to 21 months. And as I said in the prior segment, the government filed a paper on the detention. And in that particular paper, they started to lay out what they are seeing as enhancements to the base levels. They argued because of multiple victims, not just Jane and Cassie, but 5 other victims that they're going to argue is grouping, which brings up 5 levels. They're also going to argue that the defendant was a manager and a supervisor, bringing up 3 levels. They're going to argue the obstruction of justice because he was trying to destroy the video of the Cassie interaction, up 2 levels. So these are some of the things that the prosecutor is going to start to argue and probation is going to start to investigate. And that's all going to come out in a pre-sentence report written by probation that goes to the court, also goes to the defense team and the prosecutor, and both sides will have an opportunity to argue objections or departures or that enhancements are not applicable. And the defense team today were arguing only 2 levels up. So they're saying, Judge, it should only be a little off the 15 to 20 when the prosecutors are trying to get up to 51 to 63, Michael. Yeah, so that's the next fight in the case on what guideline is applicable, and then it goes to the court because they have the discretion anywhere from 0 to 10, and they follow it, but it's discretionary and not mandatory, those guidelines.
Yeah, no doubt about it. And both sides are arguing anywhere between 2.5 to 5.5. The high end, of course, are prosecutors. The low end is the defense, and those arguments will be made in front of the judge. But as you said, he's not bound by that at all. He could certainly go higher. What's interesting is that, you know, as you look at this case, one of the things that I think went under the radar is because of the fact that he wasn't convicted of the highest charge, the racketeering charge, he is not subject, I think, to forfeiture. Had they found that this was a criminal enterprise, his fortune or anything that was used in furtherance of that criminal enterprise or as a result of that criminal enterprise could have been forfeited. So he could have been facing some serious forfeiture, and his fortune, the money that he currently has, could have been taken by the federal government. Without those convictions, though, I think he's on safe ground. So on that level, it's a great victory as well for Sean Diddy Combs.
Yeah, I defer to you, Michael, on the forfeiture. I saw the forfeiture count. Whether or not it's related and has nexus to the convictions, I'll defer to you. But, Michael, you know, there's another point that I think needs to be made, and that is we saw the team that was behind this legal team. Like, we've seen it in other cases, too. You could think of the Karen Reed trial that just happened as well. What a team, right? There's so many. And right here, all of them got in front. And guess what? We didn't even see all of them, Michael. There's also paralegals behind and associates behind and secretaries behind. And you could imagine what the legal bill is and was for this particular case. And as I'm sitting here watching that, I am just, you know, I'm a little disappointed because not everyone could have the resources to have a team like that. And all across this country, while we televise cases regularly, there are hundreds and thousands across all of these counties that don't have the resources in the team that maybe if you don't have that team, you don't get that result. And that's an unfortunate part of our process.
Yeah, and they mentioned that in their statement. They said too often people are afraid to fight. I think another way you can say that is people do not have the money to fight. And they were very proud of the fact that in this instance, they did have that. They fought and they won. All right, David Bruno, stand by.